thanks, Adeel, for making the time today to answer a few of our questions. And just a quick overview of what Adeel, maybe you can share with us something about what you do with Mohammed Madani and Company Advocates, just to set context to the discussion that we're about to have.
Thanks, Renu, first of all, for having me. Adeel Madhani, Senior Advocate at Mohammed Madani and Company Advocates, and I head the Real Estate and Commercial Legal Department here at the firm. Most of you do deal with this firm when it comes to your documentation. Just a quick brief about our firm is we're a staff of 50, we're mid-tier, and we constitute 17 lawyers. Commercial, we deal with commercial real estate, estate, litigation, pretty much everything under the sun except for criminal, save for for some cases. We've been dealing with Triple Dot and most of you investors for quite some time, including, and we've given talks at some of your launches, and also for wills planning as well for some of your communities. So I think that's a good little brief to get started for today. Thanks, Renu.
Great, perfect. So Adeel is basically one of the main people with the legal team that helps a lot of the investors, as he said, and well as the buyers when it comes to buying some of the properties that we have at Purple Dot. So Adeel, in context with certain properties, especially residential, we've been having a lot of questions from our investors as well as the people buying these properties in terms of what's happening in the market right now. So the lands office has been closed. It's been on and off. It's not working consistently. And so the question on a lot of people's minds is, what is the process? So if you're buying a house now, if they're buying a property right now, what's happening? What's happening in the lands office?
Well, I can tell you that some of the other registries, not Nairobi, some of the other registries have opened, inverted commas, temporarily. So some transactions are happening. The Nairobi Lands Registry, since November, they started a scanning process, which digitized all the records at the Nairobi Lands Registry. They have about 2 million land files there. So it's quite a bit of work. They started this in November, and then there was a closure of the registry in March. And then, of course, because of Corona, the lands registry never opened. They are accepting, they are processing discharges and registration of court orders, but in terms of transactions, they haven't kicked that process off yet. Now, when it comes to buying a property, I think the first thing that everyone likes to do is a search at the lands registry to just check that the file is available, to see what's on the property. And unfortunately, if the property is situated in Nairobi, a search is difficult. In fact, it can't be done. If the property, however, is situated outside Nairobi, we've done quite a few transactions for purchases in Athi Riversides, Machakos, Gong Sides, as that those titles are registered in a different registry. So those searches are possible. Anything to do with Nairobi is a little bit different right now.
Right. So other than sorry, go ahead.
So in terms of if we can't get a search done, that also means we can't get a transfer done. However, the transactions still have to go through. So we are now providing mechanisms for buyers and sellers where both the parties are a bit more cautious when they are transacting. In terms of, I'll give you a good example. If you're selling your property to me, all right, I will say, Renu, I can't access a search, so which is the first thing, and I won't be able to transfer the property until the lands registry opens. So let us have a timeline of 90 days, which we can extend for another period of, say, 60 more days, and we'll leave the money with the advocates. And if the land registry is not open, I'll get my money back. If the land registry is open and we can transact, the monies get released to you and we transfer. So there are some transactions like that which are happening, so that things do get moving.
Yeah, because of course the buyer is concerned about what happens to the funds, right? Once he's committed the funds.
Correct. So
Yeah.
there are mechanisms that we have to tailor transactions so that both parties are protected in, somehow, noting the current circumstances.
Yeah. All right. So I'll delve into some of the specific questions that investors and buyers have been asking us. So I think this is something that you've addressed, the current procedure for the buyers purchasing the property at this time. But also a lot of times people want to know what's the breakdown of the costs, right? So in terms of buying a residential property specifically, what does the breakdown of costs look? And I'm probably going to share the breakdown that I have here, but then of course feel free to add maybe something that's missing or something that you think is incorrect or correct. But as much as this is something that the residential people ask, the buyers ask, you can also highlight if this is different or similar to the industrial buying process. So this is the costs that I have, the breakdown. There would be an agreed price, of course, that the buyer would have, and then he would pay an initial deposit, and then there would be a certain maybe payment he wants to make on completion if he's paying not at upfront in one go. Now, take us through these other costs like the stamp duty, the legal fees, the stamping disbursement, the management company, all of that, because this is something that I know a lot of people don't have clarity on.
Renu, if you don't mind, I'm just going to take a step back in terms of buying.
Yes.
All right. When it comes to developments, all right, when it comes to people buying off plan or developments, and I think for Purple Dot, a lot of their development projects are bought off plan, like they say. The only concern that one would have is obtaining a search. And again, there are mechanisms that we can put in place that protect buyers, whereby we also inform them that, look, you can pay your deposits or your installments, and in the event that when the lands office opens and you obtain a search and it's not what it seems, then there's a process of refund. That's one. Number two is we don't do registration of buyers' subleases, which are their titles for their apartments or their go downs, whatever it is. We don't do that until the development is complete.
Right.
So most of the current projects are near completion for Purple Dot. So I think what we've taken a stance is that we cross that bridge when it's time to complete and sign everyone's subleases, because I think things are completing in the next 3 to 6 months. So at that time, we'll make a decision on how to protect everyone and how to maneuver things. All right.
Okay, that's fair. I think from a buyer's perspective, that's quite fair.
Yeah. Now coming to your costs, your cost elements, you're absolutely right. Usually there is a deposit paid initially when the contract is signed. And for most buyers, if they're buying off plan, there is an installment payment where a last installment is paid when the property is complete. If it's a one-off purchase, then it's usually a deposit paid with a balance paid at the end. And if someone is taking financing from a bank, the monies are released once the transaction is complete and the property has been transferred. So since the lands registry is closed, a lot of people who are taking mortgages or financing to buy their properties are unable to pay that money because we need to transfer the property. So most of those transactions are on hold, and some banks are allowing payments to be released earlier, and some banks are being a bit rigid and they're not. Coming to these costs, for the purchase price, you have the deposit, and then you have installment payments, or you have a payment of a lump sum at the end. All right. And in terms of costs, whenever you're buying off plan, usually the buyer will pay all the registration costs, the legal fees of the vendor's advocates, and all costs associated with obtaining his sublease, obtaining a share in the management company. So if I go through this list, you have your stamp duty, which everyone knows is a 4% of the purchase price. Okay, bear in mind that when we are doing valuation for stamp duty, all right, a government valuer gets involved in that process. and he determines the value of the property. So if the property is undervalued, he will give a higher value to the property for purposes of stamp duty. So you may have to pay a higher amount for stamp duty. All right, so it's imperative that the value of the property is uniform, and it's kind of towards what the market would be selling it at. Because if you're buying a go down, which person A is buying at 15 and Renu is buying it at 5, then of course there is a big discrepancy, and the valuer will probably say, no, this value for stamp duty purposes is 15.
Yeah.
So all buyers pay a stamp duty of 4%. Most buyers, when they are buying off plan, they're buying Purple Dot, property, they will pay the legal fees of the vendor's advocates, Purple Dot's advocates. And if they use Purple Dot's advocates as well to represent themselves, they usually don't pay a second fee. So it's just a one-off legal fee. Now this depends on the development. Sometimes there is a scale fee that advocates follow, which is approximately 1.7% of the property price. But I think Purple Dot agree with their advocates that they charge, say, 1% or slightly less as a legal fee. And then, of course, there's a VAT element on top.
Yeah.
If you go down to the stamping and registration disbursements, like I said, there are some costs. There are some disbursement costs to have to register the documents, to have them valued. There's some bank charges to pay stamp duty, and that's a whole lump sum of payments to just process the stamping and registration for everyone's lease.
Right.
And that's more of a standard cost for everyone. Moving down, there is a management company formation, and I'll skip the other one, and there's a cost of purchase of 1 share. So what happens in all developments is that a management company is incorporated, and shares in the management are allocated to each buyer.
Right.
So those costs are the proportionate costs of incorporating the management company, paying the share capital, and the company secretarial costs involved in allotting 1 share to Renu, who's bought unit number 1, to person B, who's bought unit number 2, and so on.
Right.
All right. So those are nominal. Those are not very large costs. They're all quite nominal. And then if I go back to the property site plan registration costs, each plan, there's always a plan. There's always a floor plan that's that's attached to everyone's sublease. So if there are 4 flats on 1 floor, we will register 1 floor plan and identify yours as unit number 1 on floor 6. So I will have to register for Renu the plan for floor 6, the floor plan indicating unit 1 for floor 6, and then what about Renu's parkings? So there's another plan that has to be registered. So that evens itself out for everyone as well for those costs.
Fair enough. Okay.
All right. If I move down to the transfer reversionary interest costs, the transfer reversionary interest is that once all the apartments, I'm going to use an apartment building, once all the apartments have been sold, the developer transfers the reversionary interest. They transfer the title to the management company. Now the title, which is, you've transferred all the apartments and now you're left with all the common areas, and it is now owned by the management company, which is owned by all the apartment owners. Yeah. So they basically have a share in the ownership of, the rest of the property as a joint ownership. So there's a small cost for that as well. If I move down to the service charge deposit and the advanced quarterly service charge, of course, the deposit goes towards a sinking fund, which is managed again by yourselves, by all buyers, by the management. All right, that's for a rainy day, and it's a great concept to have, because what management companies do is they place that money, and you have a good 1 million or 2 million shillings, and they place that money on a fixed deposit account, and the interest, works to pay off, a one-off painting or whatever it is. It's a great initiative to have a sinking fund lying there. All right. And then of course you have your service charge payment per quarter. And then you have your electricity and water deposits and installation. There's a small cost for installation, and there's a deposit that is already placed on everyone's meters. and that cost covers that as well.
So Adeel, is this like a pretty much standard breakdown, or do you think this is something unique to Purple Dot, or is there any element here that is unique to Purple Dot?
It's actually quite standard.
Right.
In fact, if you see other developments from other developers, this will be a very standard breakdown. It's a standard breakdown that I use as well,
Yeah.
whether it's for Purple Dot or it's for other developers.
Yeah.
And this is quite standard.
Oh, good. All right. Now, I think you've already taken us through what stamp duty means and how it's calculated and how the valuator will do what they will do. Now, we would like to have a question on the sale agreement itself. So, of course, I haven't shared a copy of the sale agreement on this platform, but in the sale agreement that we have for the residential or industrial properties for Purple Dot's investors specifically, what are the clauses that come to mind for you that actually protect the buyer in case the project, for example, gets delayed?
Good question. Now, unfortunately, there are limited protection clauses for buyers, which are standard and also in Purple Dot documents. Now, I'll give you an example. Purple Dot puts up a block of apartments and says, I'll be done in 2 years.
Mm-hmm.
But then you have delays like COVID, which close the site down. You have inclement weather, which again delays your project or whatever it is, or the Chinese take over the port and we can't get our steel imports in, or whatever the case. There's always, most times, there will always be delays in construction. All right, and it's usually not the developer's fault. There are other factors that delay. So usually in sale agreements and Purple Dot sale agreements as well, there will be very limited buyer protection clauses if the development is delayed. So a lot of it has to come down to the trust that you have in the developer. And of course, there is always a sit down that you can have with the developer if they are very delayed to say, okay, how can we resolve this? Because your project is delayed and I'm losing out on my money. What I can tell you is that sometimes installment payments are pegged to construction timelines.
Yeah.
So sometimes installment payments are pegged towards timelines, which are just dates. And sometimes they are pegged to construction timelines, whereby if I finish 60% of the project, you pay me 60% of the purchase price. That way, buyers are getting value in terms of they don't pay until the project completes. Further, there's always a lump sum payment at the end. And of course, it is in the developers, it's positive for the developer if they get those payments in quickly. So they're always trying to finish as quickly as possible to get those lump sum balance payments. So unfortunately, there are no clauses to protect buyers, but there are mechanisms in the agreements whereby there's a buyer who will not pay 100% of the purchase price when the project is only 20% done.
Right.
So payments are usually staggered so that they complement the construction progress.
Yeah, I think
I also must tell you, I also must tell you that the buyer protection provision sometimes is also contractual. That means it's to do with the agreement between buyer and seller. So if the buyer and seller agree to some sort of protection clauses such as interest or an early termination, that is dependent on buyer and seller. It's more of a commercial negotiation rather than a legal negotiation.
Right. Yeah, because I think this is something we see with buyers, investors, being anxious around buying something and then saying, hey, what happens if this project doesn't complete? And I think this addresses it really well, saying that you as a buyer also have to be aware of how you pay the money and what kind of agreement you come to with the developer himself. And I think it's really important that you highlighted the fact that you have to work with the trust of somebody you trust. Essentially, it comes down to working with a developer that you trust. In general, I know you've talked about the agreement, but in terms of the laws, when it comes to buyer protection in Kenya. Do you think there's something that we can highlight to the buyers or the investors that we have that says, hey guys, this is something that you may not be aware of, but this is something that you should know?
When it comes down to buying and selling individual properties between one buyer and one seller, I'm not talking about developments.
Right.
Then yes, there are protection clauses which are standard in sale agreements, whereby if the seller does not fulfill his obligations, then the buyer has the right to terminate the transaction and get his money back. However, when it comes to developments, unfortunately, there are no set in stone laws that protect buyers from delays or abandoned construction, unfortunately.
Yeah.
And that's why you see quite a few cases or whatever it is, online or on the news. I don't want to name a few developers, but I'm sure you're aware of a few.
Yeah.
That's why, again, like you said, it comes down to the trust element with the developer, the comfort element with the developer as well. I know I've invested my own personal money with Purple Dot as well, so in a project that hasn't even started. So
yeah,
it shows the trust that I personally have with them for them to complete my construction. However, unfortunately, there are no laws in Kenya which set in stone that for developments they must finish by a certain amount of time, or what penalties the developer has if they don't finish or they're delayed. However, there is a bill which is in process, which is giving timelines for construction to complete, and which is giving some protection to buyers. But until that bill is law, the status quo remains where we don't currently have laws to protect buyers for off-plan developments.
Right. I think on a different day, maybe we could have a discussion about what you can recommend to Purple Dot in having that foresight in protecting buyers as well while this law is being passed, and then try to be proactive in terms of what they can do. But I know we have a limited amount of time today, so I'm going to try and hold that off for another day.
That's fine.
Yeah.
What you must also realize, and what the investors realize, and I think everyone understands and notes, is that Purple Dot also has a reputation that they must maintain with their investors and with their buyers. So someone who bought their first project or whatever it is, and I remember handling Greylands, their warehousing, which was so successful. I think a number of those buyers or those investors keep buying in their subsequent projects because there is that trust and that comfort with Purple Dot. And Purple Dot themselves know they must maintain their certain standard of finishing their developments on time, giving a good quality product to re-attract these investors.
Yeah, I think that again highlights the need to work with somebody that you believe in and you trust. I think it goes like any other relationship, to be honest, much as it is a business relationship, but you would put your trust in someone that you can see delivers, right?
Correct,
all right.
Yeah.
So on another note, so when a lot of people will pay up a deposit, and they get confused between getting a letter of offer and having a sale agreement, and they're not sure which one they should be more serious about. We get this question sometimes from buyers, like, okay, the letter of offer is not really committing me to anything. I'm not really committing myself. So they will sign the letter of offer, but then they don't necessarily take the next step, or they're not so confident with signing a letter of offer. They want to go straight to the sale agreement. So what's the importance of having these different sets of documents, and what should be the right process for any buyer?
That's a good question, Renu, and it's a question that clients have asked me several times. A sale agreement is your main contract. It is the main governing contract. And a letter of offer is more like a pre-sale agreement contract. However, usually the letter of offer is for people who just want to agree certain terms, commercial terms as to, okay, what's our price? What do I have to pay? How do I have to pay it? And that's it. And that's when a letter of offer is usually signed. Now, it can be practice for developers that they use a letter of offer first, where people just sign off to show a commitment. so that you can pay a small deposit, if not the full standard 10%, you can pay a small deposit, then you sign a letter of offer so that the commitment is there. Bear in mind, a letter of offer is also a contract, a binding contract. All right, so in the event that someone pays a reservation fee and then wants to pull out for whatever reason, there will be some clauses in there as to a cancellation fee or whatever it is, but it is a binding contract. The more extensive contract is the sale agreement. So what I can tell you is that some people are uncomfortable with a letter of offer and prefer to sign a sale agreement only, and that's still okay, because that is the main contract that governs the relationship between buyer and seller. Buyer pays X amount of money in these forms and on these times, and the seller has to construct whatever it is, say the apartment, in a certain way, and has to deliver it in a certain time. So both these obligations are set extensively in the agreement for sale. But a letter of offer, like I said, is for someone who wants to pay a reservation fee or a quick deposit. They sign a general letter of offer, which just state the basic terms of the agreement.
Okay. And as a developer, is it important for them to have a commitment at the point of signing the letter of offer, or is it something that the developer can say, okay, you just give the payment when the agreement is done?
There is, so in the law of contract, you don't have a contract between buyer and seller until consideration is paid. So in order to have a binding contract between Renu and myself, some money has to be paid to give validity to that contract. So if no money is paid on the signing of a letter of offer, it is invalid. But whether you sign a sale agreement or a letter of offer and money is paid, you then have a valid binding contract. So if I want to buy something for 20 million and I don't have the 2 million on me now, I will tell Purple Dot and say, I want to buy your apartment. I have a check for 500,000. Let's sign a letter of offer. We will capture the terms of the letter of offer that, I'll pay the deposit within a few days. But right now I have a 500,000 check. So will you take this? We would recommend that you first sign a letter of offer to just capture those basic terms. But then you still have a valid binding contract.
All right. Okay, so the end binding contract still remains the agreement, but of course the letter of offer would be something that you commit and reserve, right? All right. So a lot of people also ask us, as much as, and I think you highlighted this briefly, but when you're paying the lawyer's fee, is it important for us to get is it a must rather? Is it mandatory to get your own lawyer? Or as you said earlier, if you're using the same lawyer that Purple Dot, then the fee would be lower or whatever. So what's the thing that the person has to do? What's the right thing to do?
Well, everyone has the liberty to appoint an independent lawyer to protect their own interests. All right, you have every right to do so. However, because you have to pay the vendor's lawyer's fee, the developer's lawyer's fee, this is an additional expense that you have to incur independently. So that's just one element to it. Yeah. There is also no harm speaking to the developer's lawyers and requesting for certain clauses or certain provisions to protect buyers as well. And of course, that is also up to the developer to agree to such clauses or such terms. Okay, for example, an interest or an early termination or whatever it is. There's no harm speaking to the developer's advocates, to speak to Purple Dot or the developer as well if they're happy to give such clauses. All right, so you can actually do your independent lawyer's work for you a little bit. But sometimes people do prefer having an independent lawyer, and it is your prerogative to have an independent lawyer if you wish. But bear in mind there is an independent fee. What I can tell you is that a lot of developers would have a standard contract, and sometimes they don't agree to any changes to their standard contract, which means the terms of the developer are a take it or leave it term. Not unreasonable, but a reasonable take it or leave it term of the agreement. I know a number of Purple Dots are take it or leave it. They are happy to give some reasonable changes, but the contracts that are drafted for Purple Dot are not unreasonable. That's why a lot of buyers of Purple Dot units decide, okay, there's no need to have an independent lawyer because they feel that their interests are already taken care of.
Right.
So it also depends on the developer's rigidity. Now, of course, you can imagine it has become a buyer's market in recent years, but most of the Purple Dot's contracts, even though it's coming from the developers, cater for buyers' interests, and they're quite happy to take the standard format of contract that the developers give. I will also tell you that if you do request for, if buyers do ask for certain provisions or whatever it is also the prerogative of the developer to say, no, our terms are as is, and if you want to proceed with the transaction, they have to be on these terms. And sometimes the buyer says, okay, that's okay, it's fair enough, I'm being protected here. And that's how it works.
So whether I'm having my own lawyer as a buyer, or if I go to Purple Dot's lawyer, for example, what are the things that I need to look out for? So as you said, there are certain things that you need to maybe look at to be protected, whether it's the installment plan, or what else aside from the installment plan would the buyer need to look out for?
Well, the main thing is, I think just as a buyer generally, if you're generally thinking as a buyer, you just want to know, okay, what's the progress of construction? All right. When will construction be complete? All right. And Purple are quite good that if they do have any delays, they communicate that, to their buyers to say, look, we've got coronavirus issues, so we'll be slightly delayed, in completing the project. And they communicate that as well. So buyers just have to look at when the development will be finished. There's also a standard buyer protection clause in there, which is a warranty period, which is a standard 6 months that once the development is done, the developer must fix any defects or do any repairs to the building or the apartment or whatever it is for the next 6 months after.
Right.
So it's basically whether you're buying or I'm buying, it's the usual things we would look out for. Am I getting a good parking space? If the developer is promising me 2,000 square feet, am I getting 2,000 square feet? If the developer is promising me these kind of finishes, say European finishes, am I getting European finishes? So it would be the standard questions that any buyer would ask if they are buying an apartment or if they're buying a warehouse or whatever it is. Do I get parking? Where are my parkings? How many do I get? Standard questions, such as that. And all these are answered in your contracts. Or otherwise. So
right. I think it makes even more sense then to have like a letter of offer in place so that you understand what the terms are. Of course, the sale agreement would then bind it even more, clearly and say, yeah, this is what we agreed and this is what now the terms for payment or completion or whatever are. But I think it makes even more sense to have a set of documents that you can compare also and say, this is what I was promised and this is what now I'm being committed to.
Absolutely. Right. It's
Right.
also imperative that when developers are advertising, when Purple Dot advertises in their brochures and in their other documents that, look, we're building apartments or we're building warehouses, and this is what you're going to get at the end of it, that when the end product is complete, buyers will then say, this is what you advertised or enticed me to buy 2 years ago, and you've given me exactly what you've advertised that you would give.
Right.
So that's also a very important aspect of trust and reputation.
Right. I think for today, those are all the questions we had, Adeel, unless there is something that specifically, based on the discussion we've had, you'd like to add. I think the questions have been answered very, very thoroughly. I really appreciate your time.
Thanks, Renu, for having me on board on a Zoom conversation. I know this is becoming the norm now.
Yeah.
And look, if any buyers have specific questions or some concerns, you can ask them to email us directly. We are very happy to answer people's questions and to give that comfort to investors and to buyers.
Well, that's really good to know, because a lot of times people do ask us, say, hey, can we reach out to your legal team and ask them a few questions about this or that, even before them signed any agreements. In the future, if it's a valid enough question, I'm sure we will not hesitate to pass it on to you. Thank you so much, Adeel.
Thank you.
All right, thank you.
Thanks, Renu. Thank you. Bye.